summary judgment is for everyone. Summary judgment, we talked about the standards here, that the court shall grant summary judgment, so it has to do that, if the person moving for summary judgment shows there's no genuine dispute as to any material fact. We talked about what those meant. So a material fact is a fact that matters to the outcome of the lawsuit, something that goes to one of the elements that might help a jury decide one way or the other. And a genuine dispute about it means that there's enough evidence on the record to allow a rational jury to make a decision, that it's not a foregone conclusion or an obvious answer. There has to be some doubt. If there's no doubt, then there's no need for a jury. Silatex sets the current doctrine for summary judgment, and the key takeaway from Silatex is that the person who's moving for summary judgment has the same burden at summary judgment as they would at trial, and the person opposing summary judgment has the same burden that they would at trial. So your burdens at summary judgment don't depend on whether you're the movant or the person opposing. You are in the same position that you would be at trial. What that means is, contrary to what used to be the rule, the person moving for summary judgment does not need to disprove the adversary's claim. It can be enough to show that the adversary simply can't carry their burden based on the record compiled in discovery. The other really key thing about Silatex is that it assumes that summary judgment comes after the end of discovery, either after the formal close of discovery as set in the scheduling order by the judge, or simply after the party moving for summary judgment has determined they have all the discovery they need. You can no longer say, well, I'm planning to discover this information, so let's assume that I'll get it. It has to already be in the record if you're going to use it. One of the main holdings of Silatex is that the burdens at summary judgment mirror the burdens at trial. And what that means is that the parties have slightly different burdens at summary judgment from one another. So the defendant has the easier job. They need to show that no reasonable jury could conclude that the defendant is liable, and to do that, all they need to show is that the plaintiff will not be able to convince the jury on any one element of the plaintiff's claim. So maybe they can show a legal duty, maybe they can show a legal breach, maybe they can show harm, but if they can't show causation, that's enough to defeat liability. And so at summary judgment, a defendant can just focus all of its energies on arguing that the plaintiff will not be able to convince a reasonable jury that the defendant caused the plaintiff's injury. A plaintiff, on the other hand, has to show that any reasonable jury can only conclude that the defendant is liable. That means that they have to show that a jury would be unreasonable to conclude anything but liability on every single one of the elements that the plaintiff has to show at trial. And so the plaintiff's burden at summary judgment is higher than the defendant's in the same way that the plaintiff's burden at trial is higher than the defendant's, because the whole lawsuit operates against that background assumption that the defendant is not liable, and the plaintiff has to rebut that presumption at trial and at summary judgment. One key thing about summary judgment is the attitude that the court is supposed to take when looking at the evidence that the parties present. So the court is supposed to view the evidence presented in the light most favorable to the party that opposes summary judgment. And that makes sense, because if the evidence can be interpreted in two ways that allow a jury to side with the party opposing summary judgment, then that means that it should go to a jury and not be decided by the judge. Similarly, the judge is not supposed to make a credibility determination. They're not supposed to say, well, you both have witnesses for your sides, but this witness is just much better and much smarter and more credible, or this evidence is more reliable, so I think this story is a better story. If you need to decide which version of the story is true, then that means that you should not grant summary judgment and you should leave it to the jury. The court has pretty consistently insisted that judges evaluating a motion for summary judgment take that attitude that we were just talking about. But at the same time, it has, from time to time, really undercut its own insistence on that. So one example that we discussed is Matsushita in 1986, where the court basically looked at the record evidence and said, well, there's expert testimony saying that the plaintiff's claims are reasonable here, but we just don't think that that's how the economy works. We don't think that market players would do the thing that plaintiffs accuse defendants of because it's just so complicated and it's very impractical. So in the context of the whole record, we just don't think that the plaintiff's claims here are plausible. So note what the court did there. For one thing, it clearly weighed the credibility of evidence by basically rejecting expert witness testimony, which, by the way, later research shows was probably correct. And so it kind of undercuts the idea that courts aren't supposed to weigh in on credibility or talk about the strength of evidence. And basically, I think of Matsushita as giving courts a way out. So in general, you should take that attitude that we just talked about with Tolan v. Cotton. But if the claims alleged just seem so out of the realm of the plausible, if the whole record doesn't seem to the judge to support that conclusion, then it's okay to grant summary judgment and not let it go to a jury. Another place where the court kind of undercuts its insistence on this attitude is in cases like Scott versus Harris, where the Supreme Court basically rejected the conclusion of the courts below that there was at least enough of a factual dispute here to go to a jury by citing the video evidence that was entered from the dashboard camera of the police chase and saying, there's really only one conclusion we can draw from this evidence. So again, you see the court basically, I would say, denying the possibility of a plurality of views, because obviously in the courts below, it had been determined that there was a factual issue. So it can't be that obvious. But it was obvious to 8 of the 9 justices that this is how the case should turn out. And I guess both of these cases really show you a Supreme Court that is structured to be an appellate court, so taking the factual record and the conclusions from lower courts, but is sometimes eager to make its own factual decisions. And in terms of how you argue these cases, how you think about the arguments that you can make, I would say emphasize the standards that courts are supposed to take, but also fight for your client's version of plausibility as necessary.